All right, well, welcome everybody. Before we get started, I have to read our ESTA antitrust statement. ESTA and its members take seriously their obligation to comply with all applicable antitrust laws. Therefore, during this meeting and all ESTA events and discussions, all discussions will be limited to those subjects that are permitted by the antitrust laws. All members should refrain from any discussion or mention of competitively sensitive subjects such as current or future prices charged for any member product or service, current and future markets plans or strategies, and current and future costs, including employee salaries. There also must be no agreement on the suppliers or customers members do business with or the markets in which members will conduct business. Violations of antitrust laws have serious consequences. If you have questions or concerns about anything that's discussed in an ESTA meeting, please bring your concern to ESTA management. An easy-to-read pamphlet describing the antitrust laws is available from ESTA staff. So welcome to PERG's Coffee Break Series. I'm Harry Box, the PERG manager, and thanks to our members and also the AICP members who are joining us today. Today's topic is understanding your legal risks, and we are very fortunate to have a panel of experts who have spent their careers immersed in the real-world consequences of liability. So we will introduce the panel in a minute. In this meeting, PERG is also introducing a new legal document that rental companies can opt to use. It is intended to fill a major liability gap for both rental companies and production companies for certain kinds of rentals. So please stay with us to hear more about that after we hear from our experts. But before we get started, I have to thank our 2025 annual sponsors. These are the companies that show their commitment to the rental community, even during these challenging times, by sponsoring all PERG events throughout the year, and without whom events like this would just not be possible. So our sincere thanks to Applied Entertainment and Sports, Aerie, Astera, Lightgear, NFP, Panavision, and Taylor & Taylor. So please mute your mic and feel free to put your questions in the chat. We will be able to answer them as we go, maybe, or otherwise we'll have time at the end for questions. To introduce today's panel, I'm going to hand it over to a man who needs no introduction, Mr. Scott Taylor of Taylor & Taylor Associates.
Thank you, Harry. Today we have three panelists who have an in-depth knowledge of the motion picture and entertainment television industry, more specifically the terms and conditions under which motion picture camera, lighting, and grip equipment is rented to production. William Manning is a partner in Morris, Duffy, Alonso, Faley, and Pitkoff. He's an attorney who has handled claims and entertainment, and he's also his company is the legal defense, provides legal defense for insurance carriers and their policyholders. Carol Driscoll just recently was promoted to Assistant Vice President of Liability. She spent the entirety of her career handling entertainment claims for Allianz and Fireman's Fund. And last, we have David Seaman, who's the entertainment practice leader for Hiscox, and he has spent his career underwriting entertainment risks. Today's coffee break is going to focus on the liability exposures that businesses face, transferring risks to responsible parties, updating rental terms and conditions, steps that can be taken to prevent claims from happening, and the business management characteristics that underwriters look to when underwriting risks. The conversation this morning should be enlightening for anybody that's never been involved in a litigation. And I'm going to hand it over to Bill Manning.
Yes, I'm going to start by talking about the causes of action that are brought. And what we're first talking, if you have the program, I'm going to talk about number 2 first, and that's product liability. There are 3 main product liabilities in New York State. One is design defect, and that doesn't really affect rental houses. That is, the manufacturer and the designs of the product made a mistake. The second one is a manufacturing defect, and that again is for the manufacturer of the product, and that doesn't really affect directly rental house companies. The third one is known as it's worded several different ways: a marketing defect, failure to warn, or failure to instruct. This has to do with the failure to provide adequate warnings or instructions for the use of the product. There is a last cause of action, which you all know, that's not considered part of the product liability, and that's just misuse, negligence, or just plain old negligence. And we're going to be spending some time talking about that when it comes to rental products. Again, the failure to warn is something that you see all the time. And the failure to warn encompasses numerous things, such as failure to properly identify how to use the product, failure to understand that someone might have an unforeseeable use. There should be something that says that this should only be used for these purposes. Other failure to warn issues concern the product cannot be used inside, not near a flame. You must use goggles, gloves, hard hats. The driver of the equipment must be licensed. There must be a spotter. There are numerous aspects where there is a duty to warn, and that is something that is borne by the rental companies. You further have to, with respect to the equipment, you have to warn them that only competent users or instructed users should be using this product. So there's a litany of different things that the rental house needs to warn the ultimate users. With respect to negligence, and that ties hand in hand with the failure to warn, there are other aspects of negligence, and this is in the area of testing and maintenance of the equipment. A rental company will be held liable if there is no methods that they use to test and maintain the product. Many of you have probably been deposed before, and the questions go like this. They ask you a question, the second, that's followed up with, do you have any records to support that statement? Do you have any records to support that? It's a pattern that is used later on in motions that later on in the case. So it's important to maintain and test your products and to keep diligent records. Just want to go back to what's on point one. Did the rental house put out a defective product? Well, that goes back to the testing and maintenance. You should know if this product is working before you send it out. You have to ensure that the user is using it in a foreseeable manner. And again, that's in your warnings to them. And again, the other thing is, if the rental company gets this product from yet another source and is not the owner, they are still liable under these marketing defects and the ability to warn. I also want to say one thing, that we all know what the burden of proof is. The burden of proof is on the plaintiff. And that's a lovely statement. But as we all know that have been in this business a long time, it always ends up being that the defendant has to prove what they did right, that they warned them, that they did these things. The burden of proof actually shifts. And basically, that's what the rental house has to do when they're renting to production companies or something else. They have to warn them, and I can't stress enough to have records to show that you test them and maintain them.
So, going back to what Bill just said, the terms and conditions document that the ESTA PERG standard terms and conditions document, there's a requirement that the renter inspect the equipment prior to the rental, and that they let the rental house know whether there's anything that's not working properly. There's a requirement in the terms and conditions document that the equipment only be used by professionals who are licensed and who know how to operate the equipment. So it's important, it just highlights the importance of a signed terms and conditions document that outlines these exposures. One of the things, since we have production company people on this call as well, the first thing that Bill was talking about was claims against the rental house. And then we could look at how claims against the production company can arise. Did the production company receive the equipment in good working order? Did the equipment get damaged after it left the rental house? Was the equipment misused by the production company? Did the equipment damage or the misuse of the equipment cause injury or damage to a third party? So I was talking to Carol this morning, these claims, when they occur, originally there's a blur as to maybe who's responsible, or it may never be determined who's responsible. But I have 4 examples which kind of lead you in the direction of where the fault might lie. We had a case years ago where a truck was towing a trailer down a highway, and the ball that the trailer was attached to snapped off, and the chains broke, and the trailer ended up in the middle of the highway, and 2 vehicles crashed into it. That claim, on the surface, it would appear that there was probably a defect in that ball, right? Or the maintenance of the ball that the trailer hitch was attached to. We had another claim many, many years ago where we had a claim where there was a platform for 2 people to sit, the director and the cameraman, and it was designed for them to be able to sit there, but the top bar that was attached to the chair snapped, and those 2 people ended up crashing to the ground. In that case, that claim ended up going back against the equipment company. The appearance was it was probably the equipment, but there were allegations, right, that they lengthened that bar to tilt the platform down, and that's what put the stress on the bar. We have another claim with a crane where there's a weight bucket, right? And that weight bucket only allows enough weights to be put in there based on the technical standards of that crane. They don't want you to be able to overload it so the crane doesn't snap or crash to the ground. Well, somebody had the great idea, after all the weights were put in the bucket, they still wanted to put more weight on the end of the crane, and they had somebody sit on the bucket to act as the counterbalance, and then that ended up crashing. So you get into the conversations, was it foreseeable that somebody would ever sit on that bucket, right? I mean, it was designed to prevent just that type of claim or accident from occurring, yet when the claim comes in, everybody wants to argue about it. There's a saying, if you're strong on the law, you argue the law. If you're strong on the facts, you argue the facts. And if you're not strong on either, you just argue. So let's go down to the necessity of rental terms and conditions. There should be a rental terms and conditions document that exists between all parties that supply gear to a production. In the case of a production company renting from a rental house, there already is that document. In terms of a rental house sub-renting equipment, if they don't have the gear from another rental house, an agreement already exists between those 2 companies. In the case of third-party owners supplying gear, there isn't a document that exists between the third-party owner and the rental house, and that was the document that Harry was talking about. And it's really designed to create a level playing field. Each party is responsible if they were the cause of the damages. If you provided a piece of equipment that had a hidden defect that was known to you and not known to the rental house or the production company on visual inspection, you should own that responsibility. And in the world of business, most companies don't have, $3 to $5 million worth of cash sitting around to provide the defense and indemnify parties. And insurance ends up being the tool that either provides the legal defense, as Bill's firm does, and the indemnification obligation to pay damages in the event of a settlement or a court award. The terms and conditions document at the very least should address risk of loss. There should be an insurance requirement in the PERG agreement. There's a requirement that the production companies will maintain $3 million worth of liability insurance. And there's also a requirement that the rental houses will maintain an equal limit. Is $3 million sufficient in the event of a large claim? Probably not. But it was an improvement, and this was a compromise document over the $1 million limit that had previously been part of the rental agreements. There should be an indemnification provision where, the negligent party or the party supplying a defective product, they agree to defend and make the innocent party whole in the event they get brought into a lawsuit. A lawsuit usually starts out with, a claim against a certain plaintiff, and then as discovery occurs, you find out more facts, and then other parties get joined into the claim. It's essential that the rental terms and conditions document be signed by all parties. The addendum, what it attempts to do is just make the third party owner party to the contract rental agreement that exists between the rental house and the production company, whereby they agree to the provisions that are in that document. Some points that got glossed over, or Bill stated it, but I just want to emphasize it. It's important to note that the rental house doesn't have to be the owner of the defective piece of equipment to be liable, right? They're the ones who put it out into the flow of commerce, and that's the company that people are going to look to first until they discover whether there are other parties that they could pursue as well. And then I'm going to leave it to Carol to talk about the claims process, because that's what really people care about.
Yeah. Good morning, everyone. Scott had asked if I could kind of walk everyone through the process when a summons and complaint is received and forwarded to the insurance carrier. So generally, the first thing that happens when a lawsuit is received, the adjuster will review the insurance policy to confirm the coverage. And part of that coverage investigation is to determine who all the parties are and what their relationship is to our insured. If there are multiple defendants on the lawsuit, then we'll be reaching out to the insured. We'll want to know who each of those defendants are and what role they played. If they qualify as an insured under our policy, it could be that other entities that are named in the lawsuit are owned by the insured and they're already listed on our policy. That's easy. Or it could be vendors or subs that our insured has contracted with. We'll be looking for copies of any contracts that could be applicable. We'll also want to talk about, what does the insured know about this lawsuit? And this is all thinking that maybe the lawsuit is our first notice of the claim. Many times, obviously, that is not the case, and maybe we know some of these things before the lawsuit comes in. But if not, that's what we're thinking about. We need contracts. We'd love it when they're signed. And I think Bill and Scott already kind of touched upon the importance of having all of your records at your fingertips. And because a lot of times, if it is a lawsuit that we receive as a first notice, maybe it's a couple of years after the loss happened. So the better you are at keeping the records, the contracts, everything, the better off we are when the lawsuit comes in. I'll just add that all of this discussion is going to take place between us and our insureds when the lawsuit is filed. We're not going to make necessarily any determination at that time if there are additional insureds and what obligations we have, not until we get the contracts, review all of them. And if the lawsuit is the first notice, we won't be doing that until we get all of that from you. I'm going to, if I'm following Scott's guideline here, I'm just going to skip over 2 for a second. If appropriate, will retain defense counsel for the insured and potentially for other defendants if we've determined that they are also insureds under the policy. And again, probably not going to make those determinations for additional insureds or contractual indemnities yet. Once we engage counsel, they'll file an answer, there'll be strategy discussions, and a lot of that will involve whether or not we can transfer that risk back to, the contracts, and the importance of that. Also, if we are going to have obligations for other parties, we want to know that as soon as possible so we can anticipate who is going to be sending tenders, whether or not we're going to be obligated to defend and or indemnify any of them. Going back up to bullet point 2, we'll also be talking about whether or not we need experts, an investigator, cause and origin. Any of those things will be discussed at the beginning part of when we're talking about what happened and who we might need to help us defend that. And then, of course, tender the claims to those carriers or parties legally or contractually liable to defend and settle the matter. This is what we're doing throughout the investigation, even before the lawsuit comes in. We want to know who was involved, who did what, who supervised what, who provided the products, and how do we follow the path of that product if it's a product that resulted in this injury. So once the suit is filed, if we've already tendered and it's either been rejected or ignored, at that point, maybe we file a cross claim against the party that we think should be picking this up for the rental house. Maybe we have to bring them into the case completely because the plaintiff has missed them in their investigation of what happened. So that's pretty much the process that we go through when a suit comes in. There are some clarifications that Scott kind of wanted me to touch on as well. So the first one, if a third-party owner provides equipment for the rental house to use when they're renting out to a production, this topic specifically, we're talking about the third-party equipment owner. If a rental house rents out a third party's equipment and the equipment itself is defective and it results in a loss, the third party owner is not going to qualify on the policy as an additional insured under the rental house's policy. Just so everyone understands that. So I don't know what the agreements currently are, but if we're agreeing that they'll be covered if something happens with their equipment while it's on a job that the rental house has contracted for, that would not be the case. If we find out that the equipment is owned by someone other than our insured and the equipment wasn't properly maintained or malfunction, is defective, they're not going to qualify as an additional insured under the policy. Typically, the AI endorsements specifically state that the other party will only qualify as an additional insured if they're being held liable for the acts or omissions of our insured. So if it's their equipment that failed and the rental house had nothing to do with what the reason why it resulted in a loss, then the third party owner is not going to qualify as an additional insured. So let's see. Oh, and then number 2, is it possible for the rental house to be liable for injuries caused by a defective product that's not owned by them? So yes. It's also important to note that the rental house includes third-party owned equipment when renting out equipment to a job or production. They for sure can expect to be included as a defendant in any resulting lawsuit. In addition, the production company, if the production company tenders to the rental house because they provided them with defective equipment, chances are we're going to have to accept that tender, even though it's not our equipment, but we're the ones who contracted with a production company. So maybe somewhere a couple of years down the road, the case is litigated, we're able to show that a third-party owner is who is responsible, but we've already paid a couple of years of defense costs on that for both the insured and the production company. I mean, we can point the finger at the third-party owner, we can bring them into the lawsuit, but at the end of the day, if they don't have insurance and we do, then that's where the plaintiff is going to be looking. And they'll certainly target the litigation against any of the parties who have insurance. So just, you know, something, I think Scott has it up there in bold because we see it all the time. And I don't know if everybody's thinking about that when it's going on. Scott did talk about those cases that he just mentioned to you all as well. And, you know, he's describing the case to me and he's saying, so, you know, it was obvious that this is what happened. And I'm saying, well, from my standpoint, just hearing about it, it isn't necessarily obvious. He knew what happened, but I'm saying, well, who instructed them to do that? Who came in and hired the union employees? Who did this? Who used the equipment? Who told them how to use it? So those are all the things that are coming up in the discussion or the claim investigation and the discussions when we're talking about risk transfer or tendering it to vendors or someone's tendering it to the rental house. So I think when you're in the business and you're doing things, it's so common to you that you think that anybody who hears the scenario is going to come to the same conclusion that you know to be true because you are familiar. And that's not always the case. And so I think that's why the bold in point number 2 there from Scott. So I think I'm turning this back over to Scott.
Yeah, so the important points I take away from you is that carriers are not accepting tenders of claims as quickly as they once did based on contractual provisions and or what appears to be apparent liability of their customer. Therefore, what you just said is each business has to defend themselves through that entire process until they get to the point where they can either settle the claim or transfer the claim to somebody else. And what you also said is that a business owner separate and apart from the rental house will not get coverage underneath the rental house general liability policy for their own negligence or supplying defective property to production. You
Scott,
agree with those?
Yeah, Scott, you're right. And we don't accept tenders, I would say, as easily as we once did. You know, anyone who used the standard ISO CG 0001 policy knows it's a suit policy. So we don't necessarily have to accept a tender pre-suit. And we don't. We're going to wait and see what the actual investigation unfolds. Maybe it does end up in suit. Maybe we benefit from some discovery. But cases aren't settling for small amounts of money. Cases are settling for astronomical amounts of money right now. And we want people in the case with us when appropriate. If we don't know for sure, you know, who did what and who all the parties are. So Scott, yes, right.
Hey, Carol, one of
Yeah.
the questions coming up in the meeting chat is people are asking, what's tender of claim mean?
So a tender of a claim is risk transfer, if that's a more commonly understood terminology. But if we recognize that there's another party that holds some of the liability and we have a contract with them, then when we say we're going to tender the claim, we're going to transfer that risk to that party. We're going to reference the contract and say, hey, you know, you agreed in this contract to defend and indemnify us if you provide us with equipment that results in a loss. So that's what tender means. It just means risk transfer.
So some of the rental houses identify on the rental contract gear that's not owned by the rental house with the thought that they're absolving themselves of liability for claims arising from that gear. That's just a misconception. You know, then there also exists, some of the rental houses ask for a waiver of subrogation endorsement in favor of whoever's renting equipment from them. That waiver of subrogation endorsement, you know, to the extent that a claim is paid under a liability policy, will cut off the insurance company's rights of recovery, but it doesn't cut off all other third-party rights of recovery. So there are things that are being used out there where people think that they're fail-safes, but they're probably not. You know, there's no substitute for each party having liability insurance that covers their legal obligations subject to policy terms, limits, conditions, and exclusions. I think you would agree with that, right?
Yes, I mean the third party owners should have their own insurance for sure. Then, I mean, what's happening here is that the plaintiffs, they're going to target whoever it makes the most sense to target. The plaintiff attorneys are experts at doing that. If they know there's a party out there who doesn't have insurance, you can be sure they're not going to direct their case against them. So, you know, in situations like this, if a third party owner provides equipment that's defective and they provide it to the rental house and then the rental house includes it in what they rent out to a production, then you can be sure that the plaintiff attorney is going to focus their case against the rental house and or the production. They both have insurance. It makes no sense for them to go after, you know, and maybe even, you know, an individual who is the owner of that rental equipment.
You know, it's not really the small claims that I think, you know, cause, you know, in my mind, you know, me to worry about things. It's really the large claims. And if somebody wants, or if people on this call want to go back and Google, there was a fire in Ellenville, New York in June of 2019 where an entire building burned up. And that claim probably, I think the total damage is, forgetting about, I think there are some current lawsuits going around, was probably about $15 million worth of property damage. So for a production company, a rental company, a third-party owner, you know, that type of loss is a game-changing loss. There was another loss that people can, you know, go back to, was a woman who got hit on a TV show in Brooklyn in 2012. And that was a life-changing injury for that actress. So it's not necessarily the frequency of these types of claims. It's really the severity when the really, really bad one happens. Basically, you know, what I've seen in those instances is pretty much everybody tenders their limits when, you know, they end up just paying whatever limits exist. And the culpability is not as necessarily important. Let's move on to David's piece. You know, what do insurance carriers look for, you know, when underwriting risks?
Thanks, Scott. Good morning. Underwriters spend a lot of their time trying to understand risk transfer. You guys usually supply a copy of the rental contract, and that's what they spend a lot of time looking at. One of the interesting things is that if you have a really nice rental contract, it's really helpful if it actually gets signed. And that's one of the challenges we have, is that we have no control over us making sure that it actually gets signed. It's something that's important for you to be considering when you're doing it. The third party owners, we're usually assuming that you don't have a contract with third party owners. And we also are usually assuming that they don't have insurance. So if you actually have third party owners that you're renting their equipment for them. If you if you do actually have a contract with them and you're actually checking for insurance, make sure that your broker knows to let your insurance company know that that's taking place, because that's actually a really good thing, and it'll certainly help us when we're trying to evaluate the risk. Another piece that's important to know is the percentage of equipment that's owned by others that you're actually renting out. If it's 100% your equipment, from an underwriting standpoint, that's probably a better risk most of the time, because you're controlling how well the equipment's maintained and how well it's checked when it goes in and comes out. Trying to get the third-party owners to buy their own insurance is certainly again, a positive thing. We only want the rental house to be responsible for their own liability and not assume liability for others. And that's largely what we're looking for. So, I mean, at the end of the day, it's really just about risk transfer is what we're checking more than anything else, is hoping that you're not assuming liability for others and that you're making sure that you're only responsible for your liability and not taking on responsibility for others. Scott, that was a quick and dirty version of what an underwriter is looking for more than anything else.
Thank you, David. So the things that can actually reduce the likelihood of claims against either a production company or a rental house, tend to match up exactly with what a rental company has to do in order to be a member of PERG. So I guess those things work. We're coming to where there's a third-party owner addendum to the rental terms and conditions document that was drafted, and that was really intended to just close the loop on the missing contractual liability piece that exists on gear that finds its way out to production. People could either choose to use the addendum as written, amend it, or create their own, or not do anything. Some of the benefits of the addendum is there is a contractual indemnity obligation that runs from the third-party owner to the production company and to the rental house. If they're the cause of the claim, there's a requirement that they maintain insurance on the same basis that both the production company and the equipment rental company need to maintain insurance. And there's also something from a production company perspective that's helpful. The third-party owner, there's an attestation where basically they're saying that whatever they're getting paid, right, for the rental in no way, shape, or form is wages. And in the state of California, the production companies that are on this call, they're well aware of claims that have been brought in terms of wage and hour violations. In lieu of the third-party owner addendum, there could be just a sub-rental agreement similar to what exists between the rental house and the sub-vendor. But this was just an easier option to basically say the third-party owner is renting their gear on the same terms and conditions as the rental house, and they're going to abide by all the representations, warranties, conditions, that it only be operated by trained technicians in compliance with regulations and so forth. And then we have a disclaimer. Everybody should check with their own attorney, legal counsel, insurance carrier, broker, to be advised. And now we'll just take questions.
Scott, can you talk about the process by which we drafted this addendum?
Yeah, so originally it started where I drafted something, I gave it to AICP counsel, it went to ESTA counsel, it got amended, and then it came back to AICP for just some minor tweaks, and then it went to the PERG council for them to review. And I don't believe there were any adjustments at that point. I think we, completed the process through the eyes of, I guess, 4 different people. Earlier this morning, Bill and I had a conversation where he had some suggestions how to make it a little bit better. But since we had already gotten the approval of the other, the trade association attorneys and the council, we would have to bring those suggestions back to them.
Hey, Bob Donnelly's asking, does the PA picking up the gear and working on behalf of the production company qualify as someone who can sign our rental contract? Or does it need to be an owner employee of the production company directly?
Well, isn't the PA an employee of the production company? I think. I mean, I'll let Bill, weigh in on it. But in my mind, these agreements should be signed by, officers of the company, and they don't have to be signed on a one-off. They could be done on an annual basis. But I know the way the business is done is by the production assistant signing it.
You get into issues of actual authority and apparent authority. And one party can, if someone signs a document, the other party can state that person had apparent authority to do so. You have to be careful on who you allow to sign these documents, because even if they did not have your authority, the courts may find that they had the apparent authority to sign it.
Again, the comment was made, it's unclear if PAs or production coordinator are 1099 independent contractors or W-9 employees. I see about 50-50 split is the other comment that was made.
And the question is, do they have the authority to sign them?
Yeah, I guess, is it acceptable, right?
I think that's up to the company who they give the authority to sign the contracts to. But someone could rely on them signing it, yes.
I think my only comment on this it's probably better than having no signature at all.
It's true, and I think the only time there would be an issue is if someone later said, well, I didn't give them authority to sign it. So if it's our insured, or if it's the production who's asking if it's okay for the PA to sign, well, that's their decision to make. But yes, if somebody comes out later and then says, well, he's not really an employee. But then, of course, you just get into the implied contract, and if everybody did everything that's in there, then it's probably going to be fine.
And I think that largely answers the next question that's come up, which is what happens if I have a T&C signed by a person who subsequently leaves the company?
Yeah, I mean, as long as they signed it at the time as an
Right.
employee.
Yeah, that should make no difference.
Yeah, going back on one thing that Carol was talking about, in terms of no obligation for liability for third-party owned gear, you still also have the issue in terms of the property damage to that equipment should production damage it or lose it while it's on a rental. The third-party addendum helps deal with that claim in a much more predictable way than without there being any agreement.
Scott, can you talk about who has to sign this addendum?
The addendum should be signed by the three parties to the contract. If it's done as an addendum, it'd be signed by the production company, the rental company, third party owner. If it's going to be done in a way as a sub rental contract, with a sub rental house, then it would be signed by the, in that particular case, it would just be signed by the rental company sub renting the gear. The terms and conditions of the sub rental house would be signed by the rental company sub renting the gear. So what basically the third party addendum is saying is it's acknowledging basically you've got two parties that are unrelated, from a financial perspective, putting out gear to one customer, and they're just making them all part of that one rental agreement. And the production company benefits because, one, there's now $3 million more in liability insurance, to protect them in the event it wasn't their negligence or misuse, and it was actually the product they rented. And then they have an indemnification obligation from another entity.
Another comments come in from Debbie. As a rental company, we have an issue getting other sub-rental companies to sign our terms and conditions because they want us to sign theirs. Does the third-party addendum solve the problem?
It doesn't solve that problem with the sub-rental company. No. And, theoretically, right, if I was the sub-rental company, I wouldn't necessarily want to accept your terms and conditions. I would want you to sign the ones that I drafted because I feel most confident in those. Likewise, if a production company gives a rental company their terms and conditions, right, I'd probably be reluctant on that as well. One of the benefits of the PERG agreement, it was done many years ago, while it's not to everybody's liking 100%, right? It was a compromise document that was done again between, I think 5 production company executive producers and equipment rental companies, where it was vetted by AICP Council and ESTA Council. It's interesting, when that document first came out, a lot of people didn't like different terms and conditions provisions, but yet over the years, you found those very same provisions adopted into other rental agreements. So I guess from a historical perspective, whatever the intention of those provisions were seems to have worked, and people have adopted them individually.
Okay, Megan Crimmins has said there are times on film sets. Oops, it's moving too fast here. Sorry, guys. Just give me 1 second. There are times on film sets, crew members will put their own equipment on a job, even if it is not on any paperwork, grab it from their car to make a setup work. Where does the liability fall if that equipment were to fail?
I guess the question is, were it to fail and cause a production downtime, or were it to fail and cause injury or property damage?
Let's say it causes property damage, Scott.
I'm sorry?
Let's say it causes property damage or injury.
No, like Carol said, I think the production company used it, right? They accepted it. So if somebody comes after them,
Right,
And he's an
Okay.
employee of the production company.
right, if they let a crew member put their own equipment into the project and they're using it for the production, I say it's gonna come back on the production.
So some employees of production companies get paid through a loan out versus getting paid as an employee. So I think what Bill was alluding to, if they're an employee, the production company's on it.
Correct.
Bill?
Correct.
I mean, even if they're a 1099 or something like that, the production is allowing the crew member to put their equipment out there. If the crew member has insurance of their own for that, then it could go back to that. But otherwise, I would say it's going to end up being the production.
And let's say the crew member's equipment was damaged, right? And there's no rental agreement. The production company is probably only liable for the actual cash value of that equipment versus replacement cost, because that's all that was lost.
Yeah.
Sally Spaderna asks, sometimes we will have upwards of 6 or more different crew members supplying gear on a long run show. It is possible we could have them all sign one addendum, or do we need separate for each, with the production company officer having to also sign each one of these?
I would have each one signed, because they're not operating as one entity. What do you think, Carol and Bill?
Absolutely. They should each sign an individual one, and whether they have their own insurance, there should be some, if they're going to sign something, you should get some information from them, whether they have insurance on their own or not.
Yeah.
I mean, one of the best benefits of a liability policy is the defense, right? And not only do you get the defense, but you get the defense at a discount. because the insurance companies have pre-negotiated rates with their counsel, which is far superior to than what you would pay on an individual basis. And you also get people that know what they're doing.
And they added a comment, and many of them do not carry insurance. Should we be stressing that they get insurance?
I would
I
say
mean-
yes.
Yes,
too. Yep.
that's the underlying, thought here is that it's important that they have their own insurance, or else, the production company or the rental house should understand that that is part of the risk that they're going to be paying premium for sure.
And also the individual, the third party also has to recognize that they're not going to be able to contract out of their liability ultimately. So if there's, so they could actually end up without insurance, still having liability.
Correct. Yep.
If crew members don't have insurance, how useful is this addendum?
I guess it depends whether they signed it in their individual name or LLC or incorporated entity, right? I guess, right? If they signed it in their individual name, depends on what their assets are. How often do insurance carriers and counsel chase the assets of individuals if they have assets?
Well, if they have assets, we will. If
Yeah.
they have assets, a lot of them don't, it's got to be worth it if we're going to go down that road, but yeah.
That would be a reason for whoever owns third-party owned gear to have their own legal entity and have it, maintained and registered and filed properly.
I think, once somebody's putting their signature on an agreement like this, maybe that's when they'll be thinking about whether or not they need to have insurance. Maybe.
Okay, we got a couple more here. Let me just, are people above referring to kit rentals? How does insurance work in that case? I think it's the same, isn't it?
It's the same.
Yeah.
The one thing in all the years I've been doing this, everybody thinks, a certain product is just innocuous. It's never going to really cause any injury or any damage. I know of one where the suspicion is that it was an extension cord on a cart that set off a fire. You can't, it's all the things that we're never thinking about that end up being the largest losses.
I think Andrew Colon, I think what he's saying here is pretty good. He says, so is the production company takeaway one, the more insurance coverage in place by multiple parties, the better for the production company. And two, crew who own gear should be compelled to act like a business and get insurance if they want to make money from renting. I see this as an educational favor for the crew who want to rent gear, like a PSA for their benefit as well as everyone else's.
That's correct.
I
Yes.
could not have said it any better.
Very
That's
succinct.
perfect.
Very succinct.
Very good. That's
And-
the method.
And then Matthew Brown says, if we rent to a production company through a pass-through company, do we need separate T&C and COI from both companies? If we only have it with the actual production company and our rental paperwork has the pass-through company name on it, are we screwed?
Is it, I'm guessing it's a pass-through company for a state tax incentive?
I'll watch to see if Matthew responds.
Yeah, that's what I'm thinking of. If they're getting a tax subsidy from another state or another country, and they have to go through that company, and it has to have that company's name on it in order to get the subsidy.
Yeah, so that should be a sub-rental to that company in that state where they're getting the tax subsidy, and then they should rent it directly to production.
So treat it as a sub rental, and
Yeah, that's the proper way to do that.
So back to the first part of the question, do I need paperwork with both of those? Do I need a TNC and COI from both of those companies then?
You only need it from the company sub-renting it from you, and then they would get it from the production company.
Okay, and if they are a foreign-based pass-through company, we typically ask for US-based insurance. So that company's not going to have US-based insurance necessarily.
Yeah, so it's interesting, like if you're talking about a company in the UK, right? They don't have non-owned and hired automobile liability coverage that's available. So like if you're loading or unloading something out of a vehicle and somebody gets hurt doing it, the coverage there is on the auto, right? And the auto insurance usually in the UK follows the vehicle, so they don't find the need to have non-owned and hired auto. So if you're dealing with a foreign production company, you could rent directly to a foreign production company without a pass-through. You just have to vet the insurance.
Well, but the situation I'm talking about is it's an American-based production company who's actually doing the work, who's actually I've made the first contact with and have a TNC and COI from them. But in order for them to get the subsidy from the foreign country, in a specific instance, it's Thailand, they're going through another production company there that's a bit of a shell for the whole thing. So if my paperwork has that shell company name on it, will the paperwork that I've signed, the TNC that I've signed with the production company, still stand, or am I no longer renting it to them officially?
I haven't come across that situation where I've seen that, but I think if it's clear that what the intent was, I mean, that could be fine, unless the pass-through company, like Scott says, if they're somehow, influence something that results in the loss, I guess. I mean, some companies have international, foreign liability policies if they do a lot of business like that. We have policies that are, foreign GL policies for insureds who we also have a domestic GL policy for sometimes, because they have so much business that they do internationally. So some of them do have both.
Are you predominantly concerned about damage to the property you're renting?
That's a good question. Yeah, I suppose so. But no, I'm worried about liability for sure.
Yeah.
Just want to point out, I know we're getting at the end of the hour and people are going to start to leave. I just want to point out that the outline for this presentation and also the addendum is in the chat and as a PDF, and people could download it if they like.
And if there are no other questions, I think we're done. And I would just like to thank Carol and Bill for all the time they put into doing this, because this did take time.
Yes, thank you, Carol and Bill and David and Scott. Thank you for putting this together. This is really informative. Really appreciated, I think, by everybody who's attending.
Thank you.
Okay.
Thanks.
Thank you.